Welcome to the fourth session of Dispute Resolution Dialogues. Today, we're joined by Aastha and Pratyush, students from NLSIU Bangalore. They will be discussing their paper on patent illegality and sharing their insights on an empirical study that they have conducted. Over to you.
Good evening, everyone. I'm Pratyush, and I'm joined by my co-author on this paper, Aastha Malipatil as well. We wrote this paper last year, and it's published in the same year as well. So it is obsolete to the effect that it does not incorporate 2024 and 2025, a portion of it. But it does incorporate a lot of the jurisprudence that has gone behind, and that has largely stayed consistent. And that's why it's relevant to discuss how patent illegality is interpreted by the Supreme Court and the High Court, considering its high rate of usage. So we can hit the next slide. So why did we decide to pick this topic? One reason that I found out when I first began researching on this topic was that every piece of literature that we find on patent illegality is often analyzing specific cases. And all those analyses lead to the same conclusion that court is perhaps overextending its jurisdiction. Perhaps court is interpreting patent illegality to mean anything and everything under the sun because it's so broadly defined legislatively and judicially. So that was one of the reasons why I decided to go about it. And as I went into more and more cases, I realized that there are instances, there are inconsistencies that we need to analyze. And that prompted the research for this paper. So I think the correct hook to starting, so by the way, for the roadmap, I will be dealing with what is the existing jurisprudence till the Supreme Court. And Aastha would then take you over the data that we've analyzed and the findings that we think justify the conclusions that the courts have reached. So beginning with the first part that I'm leading, the correct hook for this would be a case of Alan McMaster's. I don't know if a lot of you all are aware of this, but in 2012 in the UK, a couple of students decided to edit Wikipedia and say that this random guy who's one of their friend Alex is the alleged inventor of pop-up toasters. His name, and they made up a fictional name called Alan McMaster's. What this led to was a lot of news channels, a lot of articles picking it up and saying that this is indeed true and this is a claim that is being made and UK should recognize its genius inventors. What then ended up happening was the same news articles were then cited as sources to justify the Wikipedia article. And that led to a series of cycles where everyone relied on each other to justify something's existence which did not exist in the first place. And that it was eventually debunked in around 2020, I think. But this, I think, is a great hook as to what I am about to demonstrate by the usage of cases. So the first case, as everyone knows, for patent illegality, the introduction of it, at least in the 1996 Act, was because of the ONGC saw pipes judgment in 2003. How did it justify patent illegality? So ONGC was essentially following Renu Sagar. Renu Sagar had said that there is only three grounds of public policy. Fundamental policy of the country, interests of India, and justice and morality. And it explicitly said that the mere violation of law is not a violation of the Arbitration Act. However, it was interpreting the Foreign Arbitration Act. It was not interpreting the 1996 Act, and hence ONGC comes in. What ONGC says is that if we look at section 28(1), which says that the substantive laws of the country need to be followed by the arbitration, and 28(3), that all interpretations by the arbitrator needs to be in accordance with the contract. So relying on these two provisions, ONGC said that if the award is contrary to the substantive provisions of law or the provisions of the act or against the terms of the contract, it would be patently illegal. However, coming to paragraph 31, and they said that this is in addition to the public policy's definition that Renu Sagar provided to us. And hence they added a fourth ground under public policy, which was patent illegality. Next slide, please. Now, what was the legislative basis? Considering there was nothing in the statute at that time, patent illegality as a provision only came into the picture in 2015. So how did they justify including patent illegality? They relied on two decisions, Chamse Bhara and Alopi Prasad. both of these decisions did say that the violation of a contract act is a violation and we can set aside the award. However, they are in a pre-1996 jurisprudence era. They are relying, both these judgments were relying on the 1940 Act. The 1940 Act had an explicit provision, section 16(1)(c), where it said where an objection to the legality of the award is apparent on the face of it. And that is what was being interpreted. There was a legislative mandate in the 1940 Act, which these two cases referred to. Saw pipes, ONGC versus saw pipes, relied on these two judgments but failed to take into account that such a provision does not exist anymore. As a matter of fact, a year ago in the 2002 Law Commission report, it explicitly said that we should have a ground such as error of law apparent on the face of award in section 34 or section 37. But this was not incorporated. So where was ONGC getting it? We still don't know. For 10 years, ONGC was the consistent jurisprudence. It stayed. No one challenged it. Nothing happened to it. Associate Builders comes up after almost a decade and says that ONGC is not saying anything new at all. ONGC is merely reiterating the Arbitration Act. It's saying that a violation of 28(1) means that you have to follow the laws, and hence a violation of the laws is a violation of patent illegality. 28(3) obviously says that you have to do it in accordance with the contract. And violation of the Arbitration Act is also covered under 28(1) because Arbitration Act is again a law. So it's saying that ONGC versus saw pipes is doing nothing new at all. This is the thing that they're trying to portray. However, one must realize that there is no specific remedy provided for violations of 28(1) and 28(3). Since there's no remedies provided, it does not ipso facto mean that we can attribute it to patent illegality. There's nothing to give us that indication. However, the consistency of jurisprudence indicates that that's what ended up happening. That's the next slide. So what happens after Associate Builders? There's a judgment of Foolchand Exports versus OO Patriots, where the Supreme Court extended the scope of public policy as understood in saw pipes to international arbitrations. This obviously caused a big ruckus. It was in complete violation of the New York Convention, because New York Convention did not have such a ground for international commercial arbitrations. And thus it was obviously overruled. What this led to was the 246th Law Commission report, which recommended patent illegality in 2014 for the first time. It said that 34(2)(a) should be introduced as a ground. Now, what else did it say? It said that the understanding of patent illegality is the same as understood by the court in ONGC versus saw pipes. This is explicitly written in the Law Commission report. Moreover, it said that in order to provide a balance and avoid excessive intervention, it is clarified in the proposed proviso, which ended up coming into effect as well, that an award shall not be set aside merely on the ground of an erroneous application of law or by reappreciating evidence. Now, this does not make sense again, because saw pipes literally said that the contravention of law will be a violation of patent illegality. That is one of the two things it said. It said if the arbitrator does not take into account the terms of the contract, or if the arbitrator goes against the laws, it will be patently illegal. Thus, to say that we are going to rely on ONGC to have a patent illegality standard and then say that mere violation of law will not be patently illegal is a little inconsistent. And the only logical conclusion would be is that patent illegality's sole purpose is to eradicate an arbitrator having an impossible interpretation of the contract. That's the only reason, that's the only case where patent illegality would come. However, that's not what ends up happening. We come to Singh. Singh is the first Supreme Court judgment to interpret patent illegality after the 2015 amendment. And what does it say? It reiterates exactly what I just told you. Here, there must be patent illegality appearing on the face of the award, which refers to such illegality as goes to the root of the matter, but which does not amount to mere erroneous application of law. In short, what is not subsumed within the fundamental policy of Indian law, which is public policy, the contravention of a statute not linked to public policy or public interest cannot be brought in by the back door when it comes to the setting aside of an award on the ground of patent illegality. So it's reiterating what I said. Mere violation of law will not be patently illegal. 2 paragraphs later, if an arbitrator gives no reasons for an award and contravenes section 31(3) of the 1996 Act, it would amount to patent illegality. Where does Sanghyong get it? No idea. Again, they have just said that that would not happen, and that's again what they end up reiterating. The second thing that they say, which is something we agree with, that has happened in the past jurisprudence as well, that the terms of the contract and the construction of the contract has to be of a reasonable person. And in short, the arbitrator's view should not even be a possible view to take. That is the only case where the courts can step in. Then that they were not satisfied till then. As I've said it before, ONGC versus Sopipe said that the only two things would be violation of the contract and violation of substantive laws. That is what the Law Commission report reiterated and introduced the provision. SsangYong then says that there's a test of perversity that we'll add to patent illegality as well, that somehow stays after associate builders. This is something that Aastha will elaborate on when she comes to that section. But essentially, they ended up adding a ground under patent illegality, which has no legislative basis, which has no judicial basis till this point. But they ended up adding that if a finding is based on no evidence or inadequate evidence or vital evidence, then it goes to the root of the matter and will be set aside. So now we have three grounds that exist as of today, which is violation of law, not in accordance with the contract, and perversity. There's also jurisdiction, but jurisdiction sort of overlaps with contractual interpretation, so I'm not stating it as a separate ground. So these are the grounds that exist as of today. That's the next slide. So to that end, we conducted an empirical analysis. We went over the period of 2016 to 2023, basically the period of which the provision of patent illegality existed. We only used SEC cases because it's the standard form used everywhere. It was also easier to access. It's easier to search things on it with using filters. And we restricted our analysis to high courts and Supreme Courts. And we went through over 1,300 cases, out of which 699 were relevant to our case, which we ended up using. Our preliminary observations were that it has been successfully argued in 205 out of 699 cases, which is a success rate of almost 30%. Now, you may be wondering, what is the benchmark? Is 30% a lot? Is 30% too less? We could not find an adequate benchmark within the Indian scholarship. So we turned to foreign scholarship. There was a study of about 1,300 cases conducted by this author that we've cited in our paper that went into public policy concerns, because patent illegality, again, is not a ground in most countries. So they went over public policy, and the success rate of public policy in that case is less than 20%. A study that I conducted on my own for public policy success rates in India in my third year also revealed that there's a 7% success rate for public policy. So in light of that, this 30% is too high a number. The second observation we saw was that high courts of Delhi, Bombay, and Madras dealt with almost 3/4 of the cases, which is obvious. But there was variance in success rates amongst all the high courts. What we found was, while the Delhi High Court only has an 18% success rate, Bombay has a success rate of almost 40%, 45%, and Madras High Court has a success rate of 38%. And this is absurd. How is this variance coming into play? There is no apparent reason that we could deduce, and hence this prompted a more extensive investigation, which Aastha will come to as well. And the final thing was that most parties relied on multiple grounds in the patent illegality. Although it should have only been contractual interpretation, most of them go for contractual interpretation plus perversity or plus violation of law or plus jurisdiction. They cite multiple grounds together. However, the most commonly cited is incorrect contractual interpretation, which is the ground that most parties have cited. So if you could go to the next slide. Yeah, so this is the distribution of all the grounds that have come up based on the success rate. You can clearly see that contractual interpretation and perversity dominate these grounds. And now Aastha will take you over our analysis of this empirical data. Thank you.
Thanks so much, Pratyush. Hi, everyone. I'm Aastha from the 4th year at National Law School of India. I'll be taking you across these 3 broad grounds that we ended up analyzing, which is contractual interpretation, perversity, and interpretation of law. Now, Pratyush has also already covered why contractual interpretation and perversity might be highly argued grounds, because these two, I think, give parties way more leeway to turn the case either side. But interestingly, interpretation of law, if you can see the 4th column, has the highest success rate when it was argued. It has a success rate of almost 52%. And why this is interesting is because the proviso to section 34(2)(a) clearly states that merely an erroneous interpretation of law will not be a ground for setting aside. But again, given that it has such a huge success rate, courts have gone ahead to set it aside on the exact same grounds that is prohibited. Coming to each of these three grounds and coming to contractual interpretation firstly. Now, like Pratyush also mentioned, the sort of test in Sangyong was the fact that the arbitrator should have interpreted the contract in a fair-minded, reasonable manner, and you could only set it aside where the interpretation was not even a possible interpretation. However, high courts have gone ahead to interchange this possible with the word plausible. Now, if we look at the scale that's on the screen, possible and plausible have a varying degree of certainty with them. When we say an interpretation is possible, we just say it is just a possibility. It is just that. But when we say something is plausible, we say it has a higher degree of being believable, convincing, true, certain. Now, the danger with interchanging possible with plausible means that courts get way too much leeway to say that we're not going to end at the fact that, sure, this was a possible interpretation that the arbitrator could have taken. But according to us, our reasoning is much more plausible than the arbitrators. And that's why we're going to actually end up substituting our reasoning, even while looking at just patent illegality. So this has led to, I think, increased intervention by courts where they've said and actually substituted their own reasoning for the contracts. Now, coming to also section 28.3, that was also mentioned by Pratyush before. Now, interestingly, 28.3, as it stood before the 2015 amendment, stated that the arbitral tribunal should decide in accordance with the terms of the contract. This was the provision that Saw Pipes was dealing with, and this is why Saw Pipes said any interpretation that goes against the contract will be immediately patently illegal. However, there was a clear legislative sort of moving away from these terms. This was recommended by the 246 Law Commission report, and as of 1996, as of 2015, the provision changed to the arbitral tribunal shall take into account the terms of the contract. This is what Sangyong was dealing with. There's a clear variation in these degrees. One is that any interpretation has to be in accordance to or per se the terms. But when we say the arbitrator just has to take into account, there's much more leeway. And I think that's also because you let the arbitrators have some degree of flexibility in what they want to do with the dispute. And that's why you also then respect the finality. However, again, we've stuck with pre-amended 28.3 understanding and Saw Pipes understanding. And why I think we also are very concerned with how this is going is that given the Gayatri Balasamy judgment that came up last month that now allows explicitly courts to modify awards under Section 34, and given that courts have had this long history of actually ending up modifying these awards, we're unsure whether courts are actually going to stick to the narrow grounds under 142 to exercise their powers. Coming to perversity. Now, Associate Builders, when it was dealing with the ground of perversity, said an interpretation could be perverse on three grounds. If the arbitrator considered no evidence, if the arbitrator ignored vital evidence, and the arbitrator considered improper evidence. Now, the first problem we have here, of course, is again what Pratyush mentioned, is that we don't know how this became a ground under patent illegality in the first place. Associate Builders were dealing with this under Fundamental Policy of India, which is a subground under public policy. How and where Sangyong lifted this to become a ground under patent illegality, we don't know. Secondly, the proviso seems to go right against the proviso, right? The proviso says you cannot set aside an award on erroneous application of law or by reappreciation of evidence. Now, even if we were to try and harmoniously construct the ground of perversity with the proviso, we would say that you only consider evidence or set it aside on perversity when there's an error apparent on the face of the record, which is when the arbitrator has ignored absolutely vital, apparent, obvious evidence in front of it. But again, that has not been the case. Given that perversity allows you so many of these grounds, a chunk of the cases have been on arbitrator considering improper evidence. What has this led to? This has again led to courts coming in and saying, look, we'll reappreciate the evidence. We think this evidence is better, not this. We think you should have also looked at 1, 2, 3. And since you looked only at this and not at this, etc., we're setting it aside. This is again a reevaluation and reappreciation of the evidence that is in the face of the proviso as well. Coming lastly to the ground of violation of law. Now, as Pratyush mentioned, the Arbitration and Conciliation Act as it stands today has no remedy for when there's a violation of the act in itself. This actually lacuna was observed and recognized by the 176th Law Commission back in 2002, and they recommended the insertion of Section 34A. They said 34A would mean courts could so more to have the power to remand the award back to the tribunal to remedy the defects of the act. However, that's not what happened. 34A was never incorporated. We do have Section 34(4) in the Act that allows for a remanding back to the arbitral tribunal, but 34(4) only kicks in when there's an application and request by the party. It still doesn't give so much powers by to the court itself. Now, this is a very valid concern that courts have faced time and again, which is that what do we do when there's a violation of the Act? Where do we go? And then they've made patent illegality this catch-all provision. But I think our argument has always been that if you do want a remedy, we will need a legislative amendment to that effect. It cannot and should not be under patent illegality, because patent illegality has very narrow grounds and cannot become this catch-all provision for arbitration. Courts now have interestingly not just considered violations of the Arbitration Act, but have also considered violations or erroneous applications of other laws. These laws have included the Indian Contract Act, Limitation Act, SEBI bylaws, like regulatory authority rules, regulations, all of that, to say that, look, Section 28(1)(a) says you have to decide it in accordance with substantive law. And that's why this is an erroneous interpretation and we're setting it aside. Now, even when Sangyong looked at erroneous application, it clearly mentioned that if there is an erroneous application, you cannot set it aside under public policy unless and until it's a substantive law affecting the public policy. So even when Sangyong said there is a very limited instance where you could set it aside, you could still only set it aside under the public policy ground, not under patent illegality. Now, this has now just become a ground for patent illegality, and any and every erroneous application of any substantive law in effect in India is now set aside. The problem with this again is not just that it goes against Sangyong, but it goes against the text in itself, which is very plain and clear, which is the proviso to Section 34, which says a mere erroneous application of law will not be a ground. This is where we're at, and this is how I think while the Supreme Court in Sangyong has tried its best to narrow down this restriction, and while we have the proviso as well saying appreciation of evidence and erroneous application of law cannot be a fact, high courts have gone absolutely haywire, and patent illegality has become a catch-all provision for anyone to argue everything and all the multiple grounds, and for high courts to set aside on any grounds. And this is concerning because, and the extent of patent illegality becoming catch-all is that high courts have set it aside on patent illegality, citing things like no notice was given, there was unilateral appointment by the arbitrator, arbitration the tribunal wasn't constituted as per the agreement of the parties. Now, all of these are very specific grounds for challenge under 34 itself. There's no need for it to come under 34(2)(a), which is patent illegality. And while it can be argued that, look, the end result is the award getting set aside. How does it matter what ground it comes under? It matters because this, including everything in patent illegality, will just mean high courts have way too much leeway and like way too much flexibility to include and argue anywhere, anyhow they want to, and hold anyhow they want to. And 34 was meant to be a supervisory and not an appellate provision in the first place. PI, patent illegality, becomes and gives that fertile ground for high courts to act as appellate authorities and not supervisory authorities. What do we do ahead? How do we move forward? And how do we deal with all of this? And I think one thing that we've argued also was to have narrower guidelines from the Supreme Court as well on and more enumerated guidelines, more narrow, and explaining what exactly the scope is and what high courts can and cannot do. Secondly, was to have arbitrary appellate tribunals, and it's interesting that it actually was introduced in the current Arbitration Conciliation Amendment Bill last year that does introduce appellate arbitrary tribunals, which in one sense ensures there is at least uniformity in how these provisions are being understood and how they're being applied as well. And lastly, I think there's also a need for legislative amendment on either providing for violations of the Arbitration Act and also looking at explaining the scope of patent illegality better. Now, unfortunately, what the amendment has done with patent illegality is that earlier, things as they stand today, is that patent illegality applies only to domestic arbitrations. It does not apply to international commercial arbitrations that are seated in India. Now, the amendment bill does away with this qualification and just says on an application, it can be set aside on patent illegality. This extends the scope and purview and application of patent illegality beyond domestic arbitrations to international commercial arbitrations that are seated in India as well. And this, perhaps, this great interventionist attitude that we've seen for patent illegality can actually be a setback for parties choosing India to be the seat of arbitration and a step back from India becoming, wanting to become an arbitral-friendly jurisdiction as well. And I think this is why I think, going back to what Pratyush said, we need to stick with narrower definitions, narrower scopes, and narrower intervention by high courts as well as the Supreme Court. Thank you so much.
Okay. Thank you so much. Thank you, Aastha and Pratyush, for sparing your time. And I understand that it's a hectic schedule for you right now, but thank you so much for joining us.
Thank you so much for having us.
Thank you so much, everyone.
Thank you. Thank you.
Thank you so much.